United Kingdom has dissolved as the general election is around the corner. Notably, the results of online poll held by the Labour GTV prove that the real competition in this general election is between the Conservatives and the Liberal Democrats. 82.3% of the total votes in the online poll has been cast to either one of the aforementioned party. Surprisingly, the major point which differentiates and distinguishes the voters of either party is their stance over the jury trials under the justice and crime policies. The Conservative and the Unionist Party leader Joseph Vanchi has promised to abolish the jury trials from the criminal justice system. Contradictorily, the leader of Liberal Democrats, Sumaya Agnya, has pledged to increase the number of jurors and enhance the significance of juries in the English legal system. Before delving into the thoughts of the public we are going to interview today, we are just going to watch a small snippet of the promise given by the respected leaders.
Jury is an anti-democratic aspect of our criminal justice system. It counters rule of law and it is our duty to rectify it. The first signature I'll be putting after winning this election will be concerning the eradication of juries.
The jurors lie at the heart of the English legal system, and as the representative of the mass, I will make sure to enhance the importance and significance of the jury system. Plus, our party commits to increase the number of juries.
As an honourable legal philosopher, can you please enlighten us about the juries in the criminal justice system?
Hi! So the jury system was first introduced in Britain after the Norman Conquest in 1066. The Magna Carta of 1215 gives rights for a man to be punished only pursuant to the lawful judgment of his equals, which in fact lays down the democratic rights in the UK. However, the functions of the jury has evolved over the years. Jurors acted as witnesses providing information about local matter and were largely used for administrative business. This changed under Henry II, whereby juries began to take on an important judicial functions, which were deliberating on evidence produced by the parties involved in a dispute. The rights of the jurors to give a verdict according to their conscience plays an important role, as they may acquit a defendant even when the law demands a guilty verdict. This right was enforced by the House of Lords decision in R and Wang 2005, affirming that a judge can never tell a jury to convict. It plays a vital role in making sure that the criminal justice system works for the advantage of the public rather than the advantage of unjust leaders. Alexis de Tocqueville in 1835 stated that to regard the jury simply as a judicial institution would be taking a narrow view of the matter. For great though its influence on the outcome of lawsuits, its influence on the fate of the society is still much greater. The jury is above all a political institution, and it is from that point of view that it must be judged. It has attained symbolic importance so that Lord Devlin wrote in 1956, "Trial by jury is more than an instrument of justice and more than one will of the Constitution. It is a lamp that shows that freedom lives." However, this statement led to a classic rebuttal by Penny Derbyshire, who states that juries are not random, not representative, but anti-democratic, irrational, and haphazard legislators whose erratic and secret decisions run counter to the rule of law. The main act that governs jury trial is the Juries Act 1974. The jury is considered a fundamental part of the English legal system, even though only a minority of cases is tried by jury. Unfortunately, their role is constantly being reduced to save money. Only 5% of cases are heard in the Crown Court, where juries have a role, and high proportion of these defendant will plead guilty, which means there is no need for a jury, and there are cases where the judge directs the jury that the law demands that they acquit the defendant, so that the jury effectively makes no decisions here either. The result is that juries actually decide only around 1% of criminal cases. Now let's move on to the question of whether juries understand what improper jury conduct is and understand that they must bring any concerns about improper jury conduct to the court's attention before a verdict is returned. And this is crucial to the proper functioning of jury trials in England and Wales. So why is this important? As Professor Cheryl Thompson has said, it is important to ensure that no miscarriages of justice occurs as a result of the jury process and to avoid jurors committing contempt. The specific types of improper conduct are jurors' racial stereotyping, jurors' improper use of the internet to look for information about their case, or the communication of information about the case to a third party. And this is currently the most pressing area of concern and has clear implications for a fair trial. If a specific combination of factors exists in jury trials, it can create the condition for a perfect storm of improper juror conduct. Those conditions are when jurors racially stereotype the parties, when jurors do not understand that they should not look for information via the internet or elsewhere about their case during the trial, when jurors find such information and share it with other members of the jury, where even if other jurors know this behavior is wrong, they are unwilling and do not know what to do to ensure that any verdict they return is fair. These are the areas of concern which needs to be critically evaluated in order to decide whether jury decision-making process in criminal cases are fair or unfair.
Mr. Nakiran, in your experience fighting as a human rights activist, do jurors racially stereotype defendants in jury trials?
Thank you, Ms. Cherry. George Orwell has once written that when a man has a black face, suspicion is proof. It is undeniable that racial tensions do exist in the system, as the law does not permit for an artificial creation of ethnic balance in juries. Race-related prejudices is a prevalent issue in jury trials. As the question has been directed to me, it is my responsibility to answer the question by examining it via all means. Firstly, the pejorative stereotyping aspect can be confirmed by the jurors' past decisions which have been alleged or proven to be highly influenced by the jurors' moral principles, personal experiences, personality, beliefs, predispositions, and prejudice. In the case of R. and Bryan, Lord Justice Weller has mentioned that jurors should decide without any preconceived ideas and by the reference of evidence alone. But according to Devlin et al., it has been mentioned that that is not what happens in the jury box. For example, in the case of R. and Smith, the Court of Appeal recognized that jurors may derive their conclusion from their past experiences, which nullifies the core value of jury system. As to substantiate the major point, it is imperative to look back at past cases which proves racial profiling is common among jurors. The case of R. and Qureshi is a fine illustration of such racial stereotyping attitude of jurors, where a juror in trial informed the court that some members of the juries had racially prejudiced Qureshi while forming the decision. Similarly, in a trial against Kuldeep Sandar in March 1995, a juror sent a note to the judge stating he is afraid that the defendants will be convicted not on the basis of the evidence, but just because they are Asians. As addressing extraneous factors which leads to racial prejudice, using an interpreter by immigrants and minorities itself is looked in a contemptuous way by some jurors. For example, in the case of R. and Mirza, the juror was accused of general racial prejudice as he unjustly inferred that the defendant used the interpreter as a devious ploy to help his case. To further explain the xenophobia, in a journal article by Hood et al., it was mentioned that when a defendant doesn't know English and has an interpreter, it is perceived that he's hiding behind the interpreter. Such preconceptions and prejudice lack impartiality in jury system as proclaimed by W. Lacey. Succinctly, the fact that extraneous factors governs jurors' decision is indisputable. As addressing ethnocentrism and racism in jury system, it is crucial to point out the policy and issue of same race leniency. In a report published by DOJ entitled Diversity and Fairness in Jury System, it claimed that BME jurors tend to less significantly vote to convict a BME defendant than white defendant. Referring to K. Roach, the same race leniency among BME jurors is a reflection of their belief that the courts tend to treat ethnic minorities more harshly than white defendants. These findings of reports and writings of intellectuals substantiates the notion of agreeing that juries do discriminate or racially stereotype defendants and strengthen the concern of regarding the precariousity of jury system. Every coin has two sides. Even though the above evidences prove the existence of racial discrimination or racial stereotype in the jury system, comprehensively there are many safeguards which protects the defendants and appear the jury system to be fair. According to N. King, it has been mentioned that the courts tend to apply legal test of bias. For example, in the case of R and Go, the court adopted the legal test of bias. Additionally, the Human Rights Act 1998 incorporates the Strasbourg test into domestic law, which guarantees jurors' impartiality, which was upheld in the case of Montgomery and her advocates, Her Majesty's advocates, in a 2003 case. Substantially, the English law itself provides a potential safeguards towards impartiality in jurors. Briefly, in judicially recognized safeguards, it can be divisible as prokaryotic safeguards and remedial safeguards. Succinctly, in a report entitled Are Juries Fair by Professor Thompson, it was concluded that juries overall appear efficient and effective, which ultimately underplays the element of racism in the system itself. In short, it is indubitable that there are many safeguards which protects the defendants who he or she can have a fair trial in absence of element of racism in the juries. But the effectiveness of such safeguards should be put into question and examined tentatively. As to answer the whole question in a single word, after taking all points into consideration, yes, to a large extent, jurors do racially stereotype defendants overtly or tacitly. Thank you.
Respected Barrister Rachel, do you believe that juries know what to do about improper conduct in jury room?
So the question we will look at here is whether the jurors know what to do about the improper conduct in the jury room, and whether it is, in criminal cases, the process of decision making fair or not. Firstly, let's look at what goes on in the jury room, shall we? So in a case, after the prosecutor and the defense gives their evidences to try and convince the jury of their respective cases, the judge usually sums up the cases, going over the facts of the cases and informs them on the relevant law. After that, they will be directed to a jury room. This is where the deliberations go on, where they come up with a unanimous decision on the verdict of the case in private. There will also be two jury keepers, who are people chosen from the security staff of the courts that would ensure that no one comes in contact with the jurors during the trial. The aim of this is clear, that the jurors' decision should not in any way be influenced by anyone when they are in the jury room. What is an improper conduct, you may ask? It is simple. It is when the law of the court is violated by a member of the jury, while the court case is still in progression or after it has reached a verdict. Improper conduct of a jury is a criminal offence, as it is made so by Section 69 to 77 of the Criminal Justice and Courts Act 2015. Section 77 of the Act is clear in amending Schedule 1 of the Juries Act 1974, making a conviction for the juror misconduct offence a disqualification from jury service for 10 years. So these misconducts are not taken lightly in the English legal system. One very common form of an improper conduct of a jury is when there is bias. Whether the jury is biased, has become biased, or was instrumental in creating bias among other jurors. In the case of People and Nessler, A juror told the others during deliberations that the defendant is not a good mother, and she apparently is not the angel everyone is painting her out to be. The Court of Appeal did not think that this was a misconduct affected the verdict, but thankfully the Supreme Court thought otherwise. They said that there was an interjection of extraneous evidence into deliberations that the juror failed to leave outside the room, indicating that there was a likelihood of actual bias on her part. So the judgment for the defendant was reversed. Quick question: can a jury use the internet when they are in the jury room? See, many people do not know the correct answer to that, even jurors themselves. Professor Saratha conducted a research on this matter and found that there were 23% of jurors who were unclear about the rules on internet use during a trial. Then she said that it is essential for jurors to understand the rules on improper conduct, know how and when they should report it, when they see it, and should be able to do so with ease. The problem is when there is a misconduct occurring, the jurors themselves are in the best position to detect the misconduct. However, it always falls short because if the jurors themselves observe or participates in the misconduct, then remain silent, it may never come into light. Yes, legal research can tell us much about reported instances of misconduct, but it cannot identify which individual conducted the improper conduct, as they are protected by Section 8 of the Contempt of Court Act 1981, where it provides confidentiality to the jury's deliberations. Lord Hope in R. and Misa also said that the court will not receive evidence or investigate on whatever that is said during deliberations on the verdict in the jury room. To sum this all up, it is pretty evident that jurors are governed by laws and rules that keep them in check from misconducts. However, as they, like all of us, are human beings, even if they knew of all the do's and don'ts, it is difficult for them to help with misconducts like bias, which may occur subconsciously. Hence, if the jurors themselves are not extra careful when deciding on a verdict, it will ultimately affect the decision, and hence the public will not be able to have a fair trial that they deserve. Thus, to stress this again, this is why there are statutes and laws that ensure to the best of their abilities that misconducts amongst jurors do not happen. This includes the efforts that should come from the jurors themselves. They should be well educated on the rules that goes on in the room and should have the confidence in pointing other jurors out during a misconduct. Because most of it, if not all jurors, do not know what to do about improper conduct in a jury room.
Being an IT expert and statistical analyst, can you explain how is internet affecting jury trials?
Juries are fundamentally the pillar of our justice system. The traditional media are aware that judicial contempt of courts are present in this area of the law, do not comment on the criminal history of an accused. Although there are exceptions, such as the case of Hinge Attorney General v. Demonstrate. Thus, it has become clear that there is a widespread of information about trials are being shared on social media, resulting in implication to uphold the right to a fair trial. Nowadays, some courts have used social media to publish their judgment. In this point, courts can be seen to have adopted Twitter to broadcast their verdict. For example, many state Supreme Courts in the United States publish links to their judgment and provide information about changes to court procedures and rules via Twitter. A point to note is that the provision of such access can be selective. For example, the Los Angeles Superior Court, the largest trial court in the United States, restricts access to its Twitter account, requiring users to send a follow request if they wish to do so. It is done to ensure the authenticity of the Twitter followers. Hence, the question on whether the internet affects the jury system arises. If so, how does it affect? To start, jurors' decision may be influenced by a broad range of legally relevant information obtained from media sources. With easy access to social media sites like Facebook and Twitter, jurors could potentially know the facts of the case that has not been said in the courts. Thus, selecting a juror who has not heard much about the case will be much more difficult. Evidently, this will affect the jury selection because of a large part of society already has access to these sites. Next, jurors in a case with extensive media coverage will most likely have developed some bias about the case based on the information that is already up and posted on the internet. Third, Will this person make the right decision? And are they capable of critically think about the evidence and facts about a case that are presented to them? No, they can't, as they are already influenced by the media sources. Hence, it is important that the jury is able to make judgment with no regards to any internet materials in order to produce a fair and just verdict. So, there are some facts that can prove how they get influenced by the social media. First, jurors using social media to disclose details of an ongoing trial. These activities appear to be more common. For example, there is a case in California. A lawyer who had failed to disclose his profession was suspended from practice for 45 days for blogging about a housebreaking trial while he was serving as a juror. Besides that, jurors using social media to seek responses or advice about the case. A UK juror was dismissed from a child abduction and sexual assault trial after she asked her Facebook friends to help her decide on the judgment. This is what she wrote on Facebook: "I don't know which way to go, so I am holding a poll." This was discovered prior to the jury starting its deliberations. At the end, the trial continued in her absence. Apart from that, jurors contacting members of the case by using social media. There is a case in Florida, USA. A juror was accused of friending the defendant in a trial. He was then dismissed from the trial and sent to jail for 3 days. Obviously, there are rules stopping jurors from communicating with the defense or accused, and social media use make it a lot harder to enforce this rule. Moreover, jurors can be seen to be commenting about trials on social media after the trial has been concluded. Arguable that juror misconduct after a trial is less likely to impact negatively on the due administration of justice. There are evidence that it will result in appeals and that raise legitimate concern and entail legal resources that will not have arisen but for the misconduct. In the case of Commonwealth and Wennon, 3 jurors befriended each other while 2 jurors commented on Facebook about their jury service. 1 juror also wrote about the case in his blog after the trial. In this case, the Court of Appeal refused to set aside the conviction although jury's misconduct was present, because of the overwhelming evidence that sufficiently proved that the accused is guilty. Evidently, this case illustrates the difficulties of the court in their attempt to control jury tampering via social media. Last but not least, jurors using social media to communicate with the parties to the case. The most notorious example of misuse of social media during a trial was the case of A.G. and Fryer. In this case, Joanne Fryer was sentenced to 8 months prison for contempt of court by London High Court in 2011 for exchanging Facebook messages with the accused in a drug trial while she was serving on the jury. Fryer also searched online for information about another defendant while she and the other juror were still deliberating. These activities were undertaken in contravention of a judicial instruction to avoid using the internet during the trial. While use of social media by jurors to communicate with parties to a case appears to be uncommon.
After delving into the deliberations of the respected, it can be inferred that jury system has both pros and cons. Before arriving to a decision about how fair is the jury decision-making in criminal cases, it is crucial to fathom the evaluative points of the system. The major advantage of jury trials would be impartiality recognized by Strasbourg jurisprudence. A jury is said to be impartial as they are not connected to anyone in the case. The process of random selection should lead to a cross-section of the society, and this should result in an impartial jury as they have different prejudices, thus cancelling out each other's biases. Again, such theoretical model is desired by all brave hearts of the land, which the sun never sets. But remember, the practical world is way more different than the theory proclaimed. Next, jury system is developing a more open system of justice. Justice seems to be done as there is involvement of the public in a crucial role, and the whole process is transparent. This also helps to keep the clarity of the law as points have to be explained to the jury. Besides that, this enables the defendant to understand the case better. This positive aspect proclaims justice in the legal system. Moreover, jury trials provide jury equity where juries decide the cases on their ideas of fairness, and they are not bound by precedents or acts of parliament. This can be seen in the case of R.M. Ponting, where a civil servant believed that the government were deliberately misleading the commons and the public about the sinking of an Argentinian warship. He gave copies of confidential documents to an opposition MP so that the matter could be raised in Parliament. Ponting was prosecuted under Official Secrets Act 1911, but was acquitted by the jury in spite of the judge's clear direction that defendant's conduct did amount to an offence. This is not because he wasn't guilty, but because the jury refused to convict him. This case illustrates jury votes according to their conscience. However, jury system is not an anomaly of the balance of the world. It consists of many flaws and it is undeniable. The first one would be the misuse of internet by jury dangers the fairness in jury decisions. In Cheryl Thomas' research, Are Juries Fair?, she found that 12% of the juries admitted that they had looked at the internet for information regarding to the cases they were trying. The risk of using internet is that the information may be prejudicial to the defendant. For instance, searching a defendant's name may find newspaper reports of previous conviction which the jury should not know about. Due to the increasing use of the internet, the Criminal Justice of Courts Act 2015 makes it a criminal offence to intentionally research information regarding the case on internet. Lastly, racial profiling is a major and destructive flaw in the jury system. According to Blackstone's formulation, no innocent should be punished, but due to the racial stereotyping attitude which looks prevalent among some jurors endangers the fairness in the decision-making process in jury trials. Juries' bias against ethnic minorities and immigrants endangers the notion of justice in criminal justice system. As approaching the coming general election, it would be insightful to consider alternatives to the use of juries. For example, a panel of judges is recommended by Ross-Gill Committee on Fraud Trials 1986, where 3 to 5 judges give balanced views. But there are insufficient judges in our legal system, and it is expensive to do so. Succinctly, if we depart from jury system, we may sacrifice all the benefit it provides to English land. In short, jury system has its pros and cons, and it provides impartiality and jury equity, as well as making the legal system more open. But jurors may be racially biased, and despite knowing what to do about improper conduct in the jury room, they choose to ignore it, and the jury system is immensely being influenced by the internet, which will affect the jury's deliberation. Hence, the fairness of the jury decision in criminal cases dwells a grey area, and the public representative Liberty TV do respect the significance of jury trials, but it is undeniable that it needs more reform too. Think about it before casting your vote, and ultimately may the best party win. Thank you. Signing off, Cherry for Liberty TV.
My vote is going to be for Liberal Democrats. They make real good sense. Conservatives is just creating a mirage.
Are you really sure? I mean, look at the juries. They've been racially stereotyping and they don't know the proper conducts of the jury system, and also they've been looking at the internet to find their sources. So do you really want a jury who has biased decisions?
But I think that both parties have their own good points though. I think we really need to sleep on it to really decide.
After viewing this, I still provide my unconditional support for jury system.
Anyhow guys, let's wait and watch. The elections is just near there.